friends, in this particular video, we will do an overview of Bharatiya Nagarik Suraksha second Sanhita 2023. I would refer hereinafter as BNSS. Now this is a particular BNSS which would gradually replace our existing CRPC. Not immediately, but gradually it will replace. Now this is not the first time these changes have happened, but there were various recommendations made over years by the Law Commission reports for amending this particular CRPC. There are nearly 23 Law Commission reports which suggest that there is an absolute necessity to change the CRPC. The first report being somewhere in 1963 by Justice J.K. Kapoor Committee. So this is how it has travelled. Now before having these glimpses, I would like to say that I am using the word glimpses because I am not putting forth to you section by section comparison between CRPC and BNSS. I would be stating only the new provisions, new amendments, new modifications which have come in this BNS as compared to the CRPC. Now originally in our CRPC, the sections were 484 and the new BNS has 531 sections. So there is a addition of 47 sections in BNSS. This again is because various new concepts are being introduced and because of which these sections have increased. Old CRPC has 37 chapters and new BNS has 39 chapters. So again 2 more chapters are being added in this particular BNSS. Now we will start seeing one by one the various changes which have been there in this. The first being the section 6, that is classes of criminal courts. And what are those classes? Court of Sessions, Judicial Magistrate of first class, Judicial Magistrate of second class, and Executive Magistrates. So now when I am reading this, obviously the old concept which is there in CRPC as regards metropolitan area, where the magistrates are called metropolitan magistrates. Now it seems that that particular concept has been removed from this BNSS, and as a consequence of that, you will not have additional CMM or CMM as is going. So it is now uniform Court of Session, Judicial Magistrate first class, Judicial Magistrate second class, and Executive Magistrates. So this is one of the important change which is there in this new BNSS. Now we will see section 37. Now this new concept has come. Obviously it had its root in a smaller form in the CRPC. This is designated police officer. Now original section of CRPC is also mentioned. The section reads, the government shall A. establish a police control room in every district and at state level. That's okay. Now the new part has come. Designate a police officer in every district and in every police station not below the rank of Assistant Sub-Inspector of Police, who shall be responsible for maintaining the information about the names and address of the persons arrested nature of offence with which charged, which shall be prominently displayed in any manner, including in digital mode in every police station and at the district headquarters. So now this is a particular new post which has been created, designated police officer. And because of this, the consequence is, whenever a person is arrested, immediately that police officer has to give this information to the concerned designated police officer of that jurisdiction. So this is a complete new thing which has come into picture. Now we will go to section 63, which says summons how served. Before that, forms of summon, that is section 63. Every summons issued by a court under this Sanhita shall be, now that original section in writing, I will read the new section 2. In an encrypted or any other form of electronic communication, and shall bear the image of the seal of the court or digital signature. So now this is a new thing which has come in the forms of summons. Now summons how served, we will just see that. Every summons shall be served by the police officer or subject to such rules as the state government may make in this behalf by any officer of the court issuing it or other public servant. Now the new part. Provided that police station or the registrar in the court shall maintain a register to enter the address, email address, phone number and such other details as the state government may by rules provide. So this is a new addition to it. Then the summons shall, if practicable, be served personally on the person summoned by delivering or tendering to him one of the duplicates of the summons. Now again new one. Provided that summons bearing the image of court seal may also be served by the electronic communication in such form and in such manner as the state government may by rules provide. So these are the additions. So if we see the concept of electronic communication, which is absolutely the need of the hour today, has been incorporated in BNSS for the purpose of serving of a summons on a person. Then we will go to the next section, and that is section 86. Section 86, identification and attachment of property of the proclaimed person. I will read this. This is the entire new section. Court may, on the written request from the police officer, not below the rank of Superintendent of Police or Commissioner of Police, initiate the process of requesting assistance from a court or an authority in the contracting state for identification, attachment and forfeiture of property belonging to the proclaimed person in accordance with the procedure. So, if somebody, what I understood from this is, if somebody is out of India and because contracting state, authority in contracting state, so this particular summons or this particular permission of the court can be given to that particular authority in that country to identify the property of that particular person who is being declared as a proclaimed person in India. So it's a new and a very required and necessary provision which has come in BNSS. Then we will see section 105. It says recording search and seizure through audio, video, electronic means. Now I will read that section. The process of conducting search of a place or taking possession of any property, article or thing under this section or under section 185, including preparation of the list of all things seized in the course of such search and seizure and signing such list by witnesses. Now the new addition. Shall be recorded through any audio, video, electronic means, preferably mobile phone, and the police officer shall without delay forward such recording to the district magistrate, sub-divisional magistrate or judicial magistrate of first class. So it is like search and seizure, that whole process has to be captured on audio, video means, and they have given the liberty that it can be done through mobile phone. So this is again a use of electronic communication for the betterment of justice. Then we will see section 173. Now this is information in cognizable offence, what we call as FIR. I will read that. Every information I am reading 173(1). Every information relating to the commission of a cognizable offence, now a new concept, irrespective of the area where the offence is committed, irrespective of the area where the offence is committed, may be given orally or by electronic communication to an officer in charge of a police station. And then it says, and if given orally, to be written down by the officer. Next is, if given by electronic communication, it shall be taken on record by him on being signed within 3 days by the person giving it. So, what can be seen in this particular aspect is that concept of fight for the jurisdiction. A particular police station says, no, this is not within my jurisdiction, it is with him. That kind of an aspect is now eliminated. So it is irrespective of area where the offence is committed. So this is a very welcoming provision, I think, because people who generally go for registration of FIRs, at times they have to face lot of problems based on this particular concept, because a common man does not know what is the jurisdiction, which police station I should go. He only feels something has happened with me, this is the nearest police station, let us go there. And then he lands up into a trouble. That whole thing of jurisdiction, we having, they having, who having starts. So this particular provision has eliminated all that troubles for a common man. Now we will see section 202. Correct? 202, there is only a small correction, but a very important correction. Any offence which includes cheating may, if the deception is practiced by means of, now the original CRPC says telecommunication message, but BNSS says is practiced by means of electronic communication. So again, the scope is larger. More ways of capturing an offence, more ways of reporting an offence are being captured by this particular provision by a small word called electronic communications. After this, I would like to go to section 336. 336. Now, this is a very nice section which has come, so obviously I will read the entire section. It is evidence of public servants, experts, police officers in certain cases. Now, how is made more effective? Where any document or report prepared by the public servant, scientific expert or medical officer is purported to be used as evidence in any inquiry, trial or other proceedings under this Sanhita. And now the things start. Such public servant, expert or officer is either transferred, retired or died, or such public servant, expert or officer cannot be found or is incapable of giving a deposition or securing presence of such public servant, expert or officer is likely to cause delay in holding inquiry, trial and or other proceeding. So, these are the instances where normally the delay happens. Now, what is the remedy? The court shall, this is the remedy now, the court shall secure presence of successor officer of such public servant, expert or officer who is holding that post at the time of such deposition to give deposition on such document or report, provided that no public servant, scientific expert or medical officer shall be called to appear before the court unless the report of such public servant, scientific expert or medical officer is disputed by any of the parties of the trial or other proceedings. Further, provided further that deposition of such successor public servant, expert or officer may be allowed, this is again new thing, through audio, video, electronic means. So again we see that in most of the cases the officer is not found or he is dead, he is incapable. This whole thing not only delays any inquiry, trial or proceeding, but also affects somewhere our justice delivery system. So now this is an alternative which has been derived, that fine, that officer is not able to come or he has expired, yes, then who is his successor? Who is on that post at the time when deposition is needed? Call him and take the deposition. Of course, they have also given a liberty to the defense that it should not be disputed as regards the report which is given. Of course, report, if you want to dispute, there has to be a proper and correct dispute to be raised. But in any case, this is a welcoming provision which may help in speedy justice. Now, I will go to section 356. Now, this is a very novel, new and a welcoming section in BNSS. What it says? Section 356 BNSS. Inquiry, trial or judgment in absentia of proclaimed offender. Inquiry, trial or judgment in absentia means without his presence it can be done. Now obviously the first question which will come to any defense lawyer is you are jeopardizing this, you are going against this. So they have provided the provisions. There is a procedure laid down as to how this trial would be conducted. Provide that a court shall not commence the trial unless period of 90 days has lapsed from the date of framing of charges. So this is the first thing. Now, how it is intimated? The court shall ensure that following procedure has been complied with before proceeding under subsection 1, namely. Now, these are the things which court has to do if the court has to proceed in absentia of the proclaimed offender. Issuance of 2 consecutive warrants of arrest within the interval of at least 30 days. Next, publish in any national or local daily newspaper circulating in the place of his last known address of residence, requiring the proclaimed offender to appear before the court for trial and informing him that in case he fails to appear within 30 days from the date of such publication, the trial shall commence in absentia. Next, inform his relative or his friend, if any, about the commencement of trial and affix information about commencement of trial on some conspicuous part of the house or homestead in which such person ordinarily resides, or display in the police station of the district of his last known address of residence. So these are the cautions. This is a procedure the court has to adopt before proceeding in absentia. Further, where the proclaimed offender is not represented by any advocate, he shall be provided with an advocate for his defense at the expense of trial. So, supposing after following these 4 steps, proclaimed offender comes for the trial, he will be given a legal aid. Then we have where the competent court to try case or commit for trial has examined any witness for prosecution and recorded their depositions. Such depositions shall be given in evidence against such proclaimed offender on the inquiry into or in trial for the offence with which he is charged. Now, again a safeguard, a beneficial provision for the defense. Provided that if the proclaimed offender is arrested and produced or appears before the court during such trial, so trial commenced in absentia, but during the course of trial either he is caught or he appears, the court may, in the interest of justice, allow him to examine any evidence which may have been taken in his absentia. So, it is like the trial began in absentia. During trial, the proclaimed offender came, he appeared through the lawyer. That point of time, from the day trial has commenced until the time he has come, whatever has happened, those evidences which are being there, he will be allowed in a way to cross-examine that. Again, where a trial is related to person under this section, the depositions and examination of witness may, as far as practicable, be recorded by audio, video, electronic means, preferably by mobile phone, and such recording shall be kept in such manner as the court may direct. Now further, in prosecution for offence under this Sanhita, voluntary absence of the accused after the trial has commenced under subsection 1 shall not prevent continuing the trial, including the pronouncement of judgment, even if he is arrested or produced or appears at the conclusion of such trial. So in a way, this whole section speaks of various situations in which the absence of the accused will not create a hurdle in trial. Now the question comes whether appeal is there. Yes, it is in 356 subsection 7. No appeal shall lie against the judgment under this section unless the proclaimed offender presents himself before the court of appeal. And the next part is absolutely, we must have never heard such amount of limitation period. Provided that no appeal against conviction shall lie after expiry of 3 years from the date of judgment. So probably all of us must be hearing for the first time that time period for filing an appeal or a limitation period for filing an appeal is 3 years in this particular section. I think this section would help in also removing lot of backlogs, lot of pending cases which are pending just because the proclaimed offender is not available. Hence it can't be proceeded. This must be the intention of this particular section. Now we will go to section 398, which speaks about witness protection scheme. It says every state government shall prepare and notify a witness protection scheme for the state with a view to ensure protection of witness. So I think this is a very welcoming thing, that yes, witnesses should be protected, they should feel that they are well protected, then only the proper deposition can be given by them. Then we will go to the section 472. Go to the section 472. Now this section has laid down the entire procedure for filing mercy petition. So it is mercy petition in death sentence cases. It has clearly laid down a convict under sentence of death, he can file, or his legal heirs, or any other relative may file this mercy petition. Now, as per various norms, it can be to the Honorable President of India under Article 72 of Constitution of India, or Governor of a state under Article 161 of the Constitution of India. This particular section lists down various things, how to file it, how this particular provision should be made intimated to that particular convicted person by the jailer, that he has this right. If he wants to exhaust that, he can do it. So that is laid down here. Of course, if you see 472 subsection 7, it clearly says no appeal shall lie in any court against the order of the President of India or of the Governor made under Article 72 or Article 161 of the Constitution, and it shall be final, and any question as to the arriving of decision by the president or the governor, now this is important, shall not be inquired into in any court. So, the decision given by the President of India or the Governor of the state is final. It cannot be challenged in any court of law. So, it is one way a very good provision. Now, we will see section 530. Now, this is a complete, this section is nothing but squarely fitting into our thought of e-courts. E-filing is only one of the aspects of e-court which we are doing today. But e-courts in total, what would they be? In a way, they would be a trial being conducted in an electronic mode, and this section speaks of those provisions. Section 530 of BNSS. It is trial and proceedings to be held in electronic mode. This section speaks of the all trials, inquiries and proceedings under this Sanhita, including, now what is all there in this? Issuance, service and execution of summons and warrant, examination of complainant and witnesses, recording of evidence in inquiries and trials, and all appellate proceedings or any other proceedings may be held in electronic mode by use of electronic communication or use of audio video electronic means. So, this 4 completes the definition of e-courts: service of summons, examination of witnesses, recording, including the appellate proceedings. So, this is the actually the e-court concept which has been captured here. Now, I will come to the most important question, the section which is says when applicable, how applicable, to whom applicable, that is section 531 BNSS. The Code of Criminal Procedure 1973 is hereby repealed. 531(1), 531(2). Notwithstanding such repeal, correct? A. If immediately before the date on which this Sanhita comes into force, there is an appeal, application, trial, inquiry or investigation pending, then such appeal, application, trial, inquiry or investigation shall be disposed of, continued, held or made as the case may be in accordance with provisions of CRPC 1973 as in force immediately before such commencement, as if this Sanhita had not come in force. B. All notifications published, proclamations issued, powers conferred, forms provided by rules, local jurisdictions defined, sentences passed and orders, rules and appointments, not being appointments as special magistrate made under the said code, and which are in force immediately before the commencement of this Sanhita, shall be deemed respectively to have been published issued, conferred, specified, defined, passed or made under the corresponding provisions of this Sanhita. C. Any sanction accorded or consent given under the said code in pursuance of which no proceedings are commenced under that code shall be deemed to have been accorded or given under the corresponding provisions of this Sanhita, and the proceedings may be commenced under this Sanhita in pursuance of such sanction or consent. So, what this particular thing is says that if there is a sanction accorded or a consent given under CRPC, but nothing commenced, it remained only as per sanction, and the subsequent commencement of proceedings because of that sanction, because of that consent are not commenced, they will be commenced as per BNSS. Then we have subsection 3, where the period specified in an application or other proceeding under the said code has expired on or before commencement of this Sanhita. Nothing in this Sanhita shall be construed as enabling such application to be made or proceedings to be commenced under this Sanhita by the reasons only of the fact that a longer period thereof is specified in this Sanhita or provisions are made in this Sanhita for extension of time. Now again what it says, where period specified under CRPC has already expired, in that case a person cannot take the benefit of BNSS, saying that as there is more period contemplated in BNSS, I have a chance to make that particular application or whatever proceeding is there. So this is how the application of this new BNSS will come into effect. Now I will just read some regularly used sections by us in CRPC, and then I will tell the corresponding sections in BNSS. So first I will read first I will read sections of CRPC, and then I will read the corresponding section in BNSS. Section 41, when police may arrest without warrant. Corresponding section 35. 41A, notice of appearance before police officer. Corresponding section 35, subsection 3. 50, person arrested to be informed of the grounds of arrest and of right to bail. Corresponding section 47. 54A, identification of person arrested. Corresponding section 54. 82, proclamation for person absconding. Corresponding section 84. 91, summons to produce documents or other thing. Corresponding section 94. 104, power to impound document etc. produced. Corresponding section 109. Now the chapter security for keeping peace and good behavior. The corresponding chapter is chapter 9. 125, order for maintenance of wives, children and parents. Corresponding section 144. 154, information in cognizable cases, registration of FIR as we normally call it. Corresponding section 173. 156.3, direction of court to register FIR. Corresponding section 175.4. 164, recording of confession and statements. Corresponding section 183. 190, cognizance of offence by magistrate. Corresponding section 210. 202. Postponement of issue of process, that we say inquiry under 202. Corresponding section 225. 203. Dismissal of complaint. Corresponding section 226. 204. Issue of process. Corresponding section 227. 304. Legal aid to accused at state expenses in certain cases. Corresponding section 341. 320. Compounding of offences. Corresponding section 359. 374. Appeals from conviction. Corresponding section 415. 406. Power of Supreme Court to transfer cases and appeal. Corresponding section 446. 407. Power of High Court to transfer cases and appeals. Corresponding section 447. 408. Power of Session Judge to transfer cases and appeal. Corresponding section 448. 437. When bail may be taken in case of non-bailable offences. Corresponding section 480. 438. Direction for grant of bail to person apprehending arrest, ABA. Corresponding section 482. 444. Discharge of sureties. Corresponding section 489. 482. Saving of inherent power of High Court. Corresponding section 528. 357. Order to pay compensation. Corresponding section 395. 472. Continuing offence. Corresponding section 518. 173. Report of police officer on completion of investigation, as we say charge sheet. Corresponding section 193. 300. Person once convicted or acquitted not to be tried for same offence. Corresponding section 337. 314. Oral arguments and memorandum of arguments. So it means oral arguments and tendering written arguments. Corresponding section 352. 389. Suspension of sentence pending the appeal, release of appellant on bail. During the, when we are filing bail, we also say that bail may be given to us. Corresponding section 430. 440. Amount of bond and reduction thereof. Corresponding section 484. 173(8). Further investigation. Corresponding section 193 subsection 9. So friend, this was the small overview and glimpses of the BNS. I hope you would have enjoyed this particular video, and I am thankful that you have given your valuable time for watching this particular video. Namaste.